All right. So I have everyone muted except for you and Attorney Nolen. So I wanted to introduce Attorney Nolen to you guys, and I know we're going to have some more people jump in here. Um, so I've kind of set up some questions for him. And you guys know, as far as investing in real estate and doing apartment type of investing, you can do it two ways. So you can do a bank finance transaction, and you can also do private private money transaction where you're basically borrowing the money from outside sources. So we're going to kind of get into some Q&A on that topic specifically, and how you can kind of get started and not be as weary, and know that you're protected and that you're doing things the right way as we go along. So um, without further ado, I kind of wanted to introduce him. If you have anything that you kind of want to say about yourself before we get started, otherwise I can jump right on into the questions.
Sure, I'll give everyone just a brief synopsis of who I am and my experience. So, as Mr. Hammersley stated, I am Attorney Ronald Nolen. I practice in Chicago, Illinois. I have mostly a litigator by way. My primary area of practice is real estate and property in general. So I deal with cases ranging from evictions. I do a ton of foreclosure cases. I've actually been dealing with foreclosure cases for about 7 years. You name the lender. I've gone against their legal representatives in court, practiced in 13 counties, licensed in federal court. I deal a lot with real estate closings, with evictions, condo cases. I also represent individuals and entities that are being sued by the city for building code violations. I also deal extensively with contract law in terms of drafting contracts, interpreting contracts, and litigating contracts for individuals and companies. My claim to fame case, I had a case where I represented an out-of-state trucking company against McDonald's. So, as you know, with every real estate transaction, you're dealing with contracts, that being the actual promissory note as well as the mortgage, which oftentimes a lot of non-lawyers and buyers and sellers don't understand that the difference between the two instruments, the promissory note and the mortgage itself, as you are aware, one grants you the right to borrow money, the other gives the lender a secure transaction, interest in the actual property. And so having a foundation in foreclosure defense, I feel really makes me a good or a great real estate closing attorney, because I'm able to spot certain problems at the inception that could potentially come up in a foreclosure case. Final thing I'll say, because my practice is quite extensive with respect to real estate. I am also currently tied up in litigation where I have sued a seller for breaching some of the real estate disclosures that were attached to the real estate sale contract. So it's very important to really delve into not only the body of the contract, but look at some of the disclosures and how that operates. And I think it's important for, you all play a very important role in making sure that if your client realize an issue even after closing, that he or she immediately contacts an attorney. Because in the case that I'm currently referring to, the buyers purchased the home from sellers, and they subsequently discovered that water infiltrates the basement whenever there's a heavy rainfall. However, the disclosure statement indicated that the seller had no idea or knowledge of flooding. The attorney and broker who represented my client in the transaction essentially told my client that there was nothing they could do. That was not truthful, of course. So now we're in the process of continuing litigation, and now we're at the settlement stage. Because I was able to point out to the court that there was some fraud in the transaction. So know that was a mouthful, but just to kind of give you an idea
No,
of my practice and what I do.
yeah, definitely. The audience goes, I just wanted to point out, I mean, this is an exceptional attorney that we're talking with, and so if you guys don't have notes ready yet, go ahead and get some notes out, because I'm going to dive into some questions. And speaking of the litigation, what are the penalties as far as on the end of not disclosing if you are the seller, or raising private money or raising private funding for the deal, maybe in the wrong way? What penalties would you incur, and kind of what is the severity behind those?
Okay, if we're talking about raising private funding in the context of acquiring property, am I hearing you correctly?
Yes.
On that one.
Yes.
Okay, so there's two types of potential scenarios you have here. So if it's a bank finance transaction, as you be aware, most lenders, and I should say lenders as opposed to banks because it could be a credit union, etc. But most lenders require a disclosure of where the buyer is receiving funds from. So that usually comes up in the context of, if the buyer is going to be required to bring a certain dollar amount to the closing table. Some lenders, I've seen cases where lenders may require a buyer to have like a separate escrow set up where they may require the buyer to have $10,000 or $20,000, and so the bank will then inquire as to the source of those funds. The banks or lenders are very meticulous about that, because as you have to keep in mind, and most people don't think this is depth about these transactions, but you have to ask yourself, okay, if we're dealing with a finance transaction, where is the lender getting its money from? The lender doesn't just create money. The lender is using other people's money, okay, that 9 times out of 10 is backed up by, FDIC laws. So the bank wants to ensure that the funds that are sent to a borrower will be not only protected, but that the bank itself, a lender, can have a secure interest in the, in the property itself. So that's where you always have to keep your mind first as to why the lender is requiring that information. Because what the lender is concerned about, they're thinking ahead. They're thinking litigation at the moment your client applies for funding. Okay, they're not just looking at, we're giving money away. No, they're looking at the fact that, okay, from this transaction, we're creating money in the form of interest, which you will see over in the amortization schedule. So they're looking at their potential dollars at the out in the end of the transaction, but at the same time, the bank is thinking, okay, or lender is thinking, in the event that we have to sue this individual to foreclose, can we truly protect, our interest in this property? And if we get to that point, will there be anyone else or any other entity that can claim an interest in the property? So that's why, most lenders will ask about the source of funding. And so if what they want to find out is, okay, is there a family member or someone else that is truly just giving the money away? And that's why you will see lenders, if they find out that someone has someone money, they want an affidavit stating that that individual will not, subsequently claim an interest or seek the repayment of those funds from the borrower. So just to kind of, like I said, I know that was a little more in depth, but just making sure you have a full understanding as to why lenders are concerned about potential third-party investors, because if they want to foreclose on the property, they'll have to deal with one or more persons, coming to court saying, hey, we have an interest in this property as well. So they want to make sure that, they're number one, and the only one in most cases, that can actually have a stake in the property. With respect to a strictly private situation here.
as far as raising private funding?
Right, and right.
Okay.
In terms of raising private funding, you usually get into trouble or issues when you fail to honor the written contract between you and the investor or investors. So that could come in the form of if you fail to if it's a rehab, if you fail to meet certain deadlines, or if you fail to pay the investors their respective percentage interest from the deal, then you're looking at a breach of contract action.
Okay. And so I guess what would be some of the penalties for that?
Oh, so contract penalties and or potential attorney fees depending on the case. So, for example, if someone in a strictly private transaction where you're dealing with penalties from failing to honor the investor's contract, you're looking at the difference of what that investor was entitled to. So, for example, if the investor invested, just using whole numbers, invested $2,000 in a certain transaction and was expected to receive $10,000 in revenue from a profit rather, then you're looking at around an $8,000 contract, because there'll be a difference between the two and the and the 10. Now, in addition, you could be on the hook for court costs and or attorney fees depending on the state that you're in and the terms of that contract. So I'm kind of giving you all some clauses that will go in favor of the investor, other clauses that may go in favor of you as the realtor or persons who are actually looking to obtain a profit from it. So if you're on the investor side, you want to make sure your percentage and dollar amount is clear. You may want to know, how many properties your money will be used for. If you're on Mr. Hammersley's side of the equation, you want to try to limit the number of other persons that investor can invest money with. And you may say, hey, well, in this contract, I want an exclusive agreement, where I will be the only one that you will invest in for maybe a year or two. So that way you're locking that investor into an agreement where, okay, if this person should want to, engage in further investments, they can only deal with you exclusively. Or it could be something less than that. It could be, I want you to give me 75% of your business, or give me the first right of refusal. So, like I say, there are a myriad number of ways that you can actually structure your agreement, which will determine, the terms that will be in each clause.
Okay. All right, that makes sense. Well, go ahead. I'm sorry.
I'm sorry, Ms. Hamilton, if I may. Something that I want to discuss as well, if I may. I want to briefly discuss the differences between bank finance transactions and owner finance transactions. But sometimes there are questions about clear definitions and how exactly that operates. So as you know, bank finance transactions is getting the money directly from the lender, if you will. Now with an owner finance, which is sometimes called a seller finance transaction, that's where you will have a situation where it could be a bank or it could be a private individual. So let's just use the example of a private individual. So Mr. Hammersley owns a real estate that he's seeking to sell, and I'm going to use myself, and I'm the prospective buyer. And for whatever reason, I may be unable to obtain financing from a bank or another financial institution, or I may simply not want to entertain the current interest rate. Okay, so I could enter into an agreement, and once again, check the state laws for different things that vary. But I could potentially enter into an agreement with Mr. Hammersley, whereby I'll say, okay, Mr. Hammersley, I want to purchase this property from you, but I can't, for whatever reason, I can't obtain financing. So we could actually draft a contract where he will sell the property to me. Now, it could be considered like a lease to own, or just simply an installment payment, agreement, whereby at the end of a certain time period, he will agree to transfer title to me. So you do have some situations like that where the person that's actually selling is not only the seller, but the individual that is financing the transaction itself.
I'm glad that you pointed that out because especially in single family homes, we've done some of that, and we've also had several offers on multifamily that owner financing is present. So, I'm glad that you point that out because a lot of people don't really understand how it works a lot of time. And coming from you, I know that you definitely cleared that up for a lot of people, I'm sure.
Just make sure, once again, if you do that the contract is drafted very tightly and that you have protections in place.
And speaking of that, as far as how to get in contact with you and sit down with you for a consultation for the people who are listening in the Chicago area, what would be the best way to get in touch with you?
Well, I have reached at area code 312-394-0184 or by email at Ronald, RONALD, dot, Caleb, dot Nolen. And
the conference has been locked.
.com. And if someone who's listening is not from the Chicago area and may need a referral for a real estate attorney, I do have referrals in some of the surrounding states as well.
Okay, yeah, that would be great. Definitely. Because I know I'm looking at the area codes here, and we've got, 904, 812, 216, 678, 404. I know that's down in Georgia. 570, I believe that's Virginia. So, but yeah, definitely, I appreciate, the call. And also, one more thing right before we get off here, I wanted to kind of clarify something because I didn't know if anybody else wasn't sure what this meant, but I wanted to clarify it for myself. To ask about the FDIC laws and just to kind of explain a little bit more of that and what that is and how those work.
Okay. So I'll just give you just brief it for you.
Okay.
So as you know, most things are backed up by the federal government, if you will. So it's federal deposit insurance is what it is. So what it is, it gives us as consumers in America, peace of mind to know that when we make deposits at an FDIC institution, that our funds are going to be protected. And so that's why if you go into certain banks, you see the gold plate that says FDIC, insured, and it's usually insured up to a certain amount of money. So this is why, and that's a very good question. I won't say that, but I'll just say I know an attorney very well who was recently convicted in federal court for mortgage fraud. Okay, so that's a very big concern when you're dealing with any real estate transaction. But just to bring it on home, how it's relevant, once again, when financial institutions use our money that's federally insured, okay? So that's why when someone commits a criminal act on the bank in the form of robbery or even mortgage fraud, wire fraud, that's why those cases are prosecuted in federal court and not in state court, okay? Because you're dealing with funds that are backed up by the federal government. So when you're dealing with real estate transactions, I'm going to show you this. If you lie on an application for funding from one of these institutions that are secured by the federal government, and subsequently at the closing table, checks are issued after that entity has transferred or wired money to the closing company, to the title company, to effectuate the closing, you have committed wire fraud because you have misled this institution by whatever misrepresentation your client has made or you have caused your client to knowingly make to obtain those funds. So you must always be concerned about the intent. And that's why at the inception of this conversation, I said full disclosure. You know, if the financial institution is asking, okay, have you received funds from a third party, you need to disclose that, because each of you may have a license to protect, whether that may be as a real estate broker, someone on this line may be an attorney, you know, a CPA, whatever, you know, and if not, you still don't want to go to jail, you know?
Right.
So, you know, so these are some of the penalties. So when we think about, we hear these actions about wire fraud, you're like, how can that happen? You know, why it's wire fraud? Because you lied. And because of that lie or misrepresentation, however you want to phrase it, you induced this financial institution to lend money. Because otherwise, the financial institution probably would not have allowed you to borrow those funds. Right. And so, you know, going back to the case where the attorney I know very well, who was practicing for over 30 years, you know, he's now been disbarred and is due to begin his sentencing because he was engaged in a scheme with two realtors and another individual whereby they would intentionally manipulate answers on applications and create documents. I mean, it was just a very extensive scheme to defraud the banks out of the money. And then, of course, you know, the interest for them was that, okay, if they were on the realtor side, they, of course, were going to receive a broker's commission. And then, of course, as the attorney, he would receive attorney fees. So,
okay.
Just be honest.
Yeah, definitely be honest. Yeah, because you don't want to get yourself in a situation like that. So yeah, I just wanted to say thank you again. I mean, we all greatly appreciate it, and I also kind of, for everybody still listening, I'm gonna have a PDF of my notes of the conversation, just to kind of mind map over some things in physical written form, because I know some people learn better that way. And also, if you guys want, I typed out a little PDF also on top 10 factors to consider when making your first offer on your apartment and an apartment building. So I'm gonna jump off here. I just want to say thank you again, Attorney Nolen, and
thank you.
And thank you everybody else that tuned in.
Eyes in the sky, gazing far into the night. I raise my hand.